here. It mentions the former name of my law firm, which is now almost 3 years old. I lead the global privacy practice at Hogan Loveless, and also I'm the founder and co-chair of the Future Privacy Forum. My name is Chris Wolf. Mr. Schaar.
Well, my name is Peter Schaar. I'm the Federal Commissioner for Data Protection and Freedom of Information of Germany.
Felipe Rotondo, presidente de la Unidad Reguladora y de Control de Datos Personales de Uruguay.
My name is Josh Harris. I'm with the International Trade Administration and the United States Department of Commerce.
Hello, my name is Jorg Polakiewicz. I'm in the Council of Europe.
Hi, I'm Julie Brill. I'm a commissioner at the Federal Trade Commission in Washington, D.C.
Hi, I'm Sigrid, and I'm a commissioner from Mexico, EFI.
Wonderful. Thank you all panelists for being here. And our topic is a big one, which is self-regulation. And maybe the way to frame it is to acknowledge what is the obvious, which is privacy is a shared responsibility. There obviously is a role for government and for law. We've been talking about that for most of today. There's a role for regulators and for regulators. For regulations and for regulators. There is a role for enforcement. There is a role for media. There's been a lot of attention focused on privacy in the media recently. There's a role for the academy and their forward thinking. There's a role, obviously, for civil society, which is why many of us are gathered here today. And yes, there's a role for businesses that handle personal data. And that role exists either for businesses alone or in concert with others. And so the question for the large overriding question for today's panel is what role businesses should have for self-regulation, whether it is to comply with the laws and regulations that are set for them, or irrespective of such laws and regulations, to advance privacy generally. So what I thought I would do, at least for this first question, is ask each of the panelists to discuss, in their view and from their perspective, what the critical components of a self-regulatory mechanism is. So, Commissioner Schaar, we'll start with you.
Well, thank you very, very much. Well, the basic question is, do we need any regulation, and which kind of regulation? And there are different components, there are different ways to come to different goals. From my perspective, the basic question might be, should the society remain in control on what's going on in the information society? And I would say yes, in democracies, the people at last has to set up rules by parliamentary decisions, and the individuals as well as companies have to follow those rules that were set up by the parliaments. Well, that does not mean that every single rule will be defined by law. There is space for self-regulation. But the self-regulation could not be an alternative to laws. I would say it can be another way to help to implement laws and to combine different interests and to balance different interests. And therefore, I would say self-regulation could help us to come to better results if it is a very strong self-regulation, and we do not need self-regulation to the companies. It should also be a kind of regulated procedure where some basic requirements, at least, have to be set by the parliaments.
Felipe.
En mi exposición, ante el planteo del panel, me pregunto si es una opción adversativa. Existen valores en juego que son de consumidor, del usuario, de la persona humana como centro del sistema jurídico democrático. Pero también hay valores colectivos muy variados, de la salud pública, seguridad pública, etcétera, pero que siempre esos valores colectivos se individualizan. O sea que los intereses privados y los intereses colectivos no hay que oponerlos. En realidad, ambos integran el interés público. El interés público en el que cada uno no vea de nosotros realizado su situación personal de alguna manera no es sino una falacia, señor. Quiero aclarar que estoy hablando, sobre todo, anteponiendo mi calidad de profesor de Derecho Administrativo, y nosotros entendemos como característica fundamental del Estado de Derecho democrático el centro de la persona humana y el principio de subsidiariedad. O sea que el Estado tiene un papel de orientar, de apoyar y cuando corresponde, de suplir, si es necesario. Y me remito a las palabras de un profesor de Derecho Administrativo español, amigo, no por amistad, sino porque creo que es válido lo que dice el doctor Jaime Rodríguez Arana, que dice que desde los postulados del pensamiento abierto, plural, dinámico y complementario, podríamos decir que la apertura a la realidad, la aproximación abierta y franca a las condiciones objetivas de cada situación y la apertura a la experiencia son componentes esenciales, actitudes básicas del talante ético desde el que deben construirse las políticas públicas. Un pensamiento que quiera abordar con éxito la comprensión de la realidad, tal y como la perfilamos, debe ser un pensamiento compatible, un pensamiento que no encaja en modelos rígidos y planos y tiene capacidad, precisamente porque trata de comprender al ser humano en todas sus dimensiones, de conciliar lo personal y lo social, lo estatal y lo civil, la libertad y el ordenamiento, el mercado competitivo y la regulación político-económica. Con esa base yo tendría más que agregar, pero me parece que estamos haciendo como una presentación de cada uno de nosotros, porque creo que eso deriva en que la regulación pública debe existir, pero en mi opinión debe existir en los lineamientos fundamentales, en el establecer o recoger o explicitar los principios, y salvo en aquellas materias, como dije antes, de la seguridad pública, digamos, como se ha planteado en Estados Unidos respecto a los brokers, ¿no?, a los intermediarios de información, etcétera, salvo esos casos, dejar mayor campo a la autorregulación. Pero comparto lo que decía Peter Schaar en el sentido de que no es solo la autorregulación, pero esa autorregulación implica un aspecto de responsabilidad social, un aspecto de desarrollo del principio de participación ciudadana o participación social, y por lo tanto no hay que verla opuesta a la regulación estatal, sino un paso más, un plus que contribuye a la protección de los derechos. Por ahora me parece mejor dejar acá para...
Perfect way to begin. And Josh, next, please.
Thank you. Well, I think I would probably like to start by acknowledging that, in all likelihood, self-regulation is going to continue apace in a variety of venues. Sometimes they're going to happen at the national level. Sometimes they're going to happen at the subnational level. Sometimes they're going to happen in multilateral venues. And so what this means then practically is that you're going to see self-regulatory initiatives not necessarily connected to one another, sometimes on the very same issue, developing in different places and at the same time. So the main question for me is really then one of process, and that is, how do you take these different initiatives that are springing up everywhere and make sure that they can function together? In other words, how do you make these initiatives interoperable? But beyond just making these initiatives interoperable, how do you make them interoperable in places where there has been a proposed solution to a specific issue, and that solution is law? How do you make the self-regulatory construct applicable there? And so what I would say is first, you need to have enforcement ability. Any self-regulatory system that's going to be developed, that is going to be put out there on the table for negotiation with either another country or another institution for any kind of cross-recognition is going to have to first be enforceable. But beyond being simply enforceable, there needs to be built into this system kind of an accountability. Now, what that form of enforceability is, that's to the terms of the specific actors that are actually undergoing those negotiations. And what that kind of accountability is, again, that would be to the specific circumstances regarding the specific negotiations. But I would just put forward that I think those two elements are critical to the success of any kind of self-regulatory infrastructure being able to take root not just locally where it was proposed, but across borders, which I think increasingly is where the main relevance of a lot of these things, especially insofar as they relate to privacy, happen. Thank you.
We're going to get back to those issues of enforcement and accountability, but Jorg, from the Council of Europe perspective, what do you think are the essential or the critical components of the self-regulatory mechanism?
Yeah, I must say I agree very much with what was said by Peter Schaar and Felipe Rotondo. I think from the Council of Europe perspective, of course, the starting point of the discussion is that data protection is a human right. So you cannot leave it alone to private actors to set the rules of the game. Where fundamental rights are at stake, it's for the state authorities in the democratic process, first of all, to fix the regulatory framework. Of course, this doesn't mean that there should be no room for self-regulation. This is clear that self-regulation, in particular in an area like data protection and privacy, which is confronted with such a rapidly evolving technology, has to have resort to this kind of regulation. But it should be always within a clearly democratically defined legislative framework. And to give the example, this is also acknowledged, by the way, very explicitly by Convention 108, which requires states to take the necessary legal measures in its domestic law to implement the principles of the Convention. And so the first step is to be that the state has to create a legal framework, adopt comprehensive data protection legislation. Of course, then, as a complement, there is a lot of room for self-regulation. As the explanatory report states, binding measures may usefully be reinforced by measures of voluntary regulation, such as codes of good practice and codes of professional conduct. However, such voluntary measures are not by themselves sufficient to ensure full compliance with the Convention. To your question, what should the legal framework set? I think it should set basically 5 components of self-regulation. First of all, the aim, then the procedure. I think it's important to involve not only industry, but also civil society and professional associations. There should be incentives for participation, also possibly the margins that are left to private actors. Very important, there must be some kind of verification of compliance of the implementation of whatever self-regulatory regime is eventually adopted. Because without any implementation, I think it will remain quite a theoretical regime. And of course, lastly, it should also be clear what is the relationship between the self-regulation regime and the legal framework. I think this needs also to be clarified by, as I said, by state regulation before any self-regulation can come to play.
Great, thank you. Julie.
Hi, so we have a fair amount of experience in the United States with self-regulatory mechanisms. Probably the most important, just to directly answer the question, which was, what are the critical components of a self-regulatory mechanism? I think the most critical is probably the standards, and that the standards are meaningful. And I want to circle back to that because the way in which standards are set for a self-regulatory mechanism vary and can be quite significant in terms of whether or not those standards are in fact going to be meaningful and in fact are going to lead to real improvements and help for consumers, which is the ultimate aim of self-regulatory mechanisms, in my view. But in addition to setting meaningful standards, there's some other critical components too. You need to have a compliance mechanism. That is, you need to have a way for enforcing the meaningful standards. And that, the first line of defense, if you will, in terms of ensuring that the standards are complied with, ought to be the self-regulatory entity itself. It needs to have some kind of an enforcement mechanism. But then after that, if the self-regulatory organization itself is having trouble dealing with enforcement, or it's got an egregious player, or there's just a problem that needs to be addressed at a bigger level or greater level, then I think there needs to be governmental enforcement as a backstop. You need to have another critical component of an effective self-regulatory mechanism is going to be widespread industry adoption. If you have a self-regulatory mechanism that only a few players are abiding by, or if you have a self-regulatory mechanism that's been established by dominant players only, that could really result in some problems. In particular, it could lead to some serious competition issues, which is another area that we spend a lot of time looking at the Federal Trade Commission. There are some other components that are helpful: third-party certification, a dispute resolution process that might be short of an enforcement mechanism. But I think the four that I described are really the critical components. So let me circle back to how meaningful standards are set up, and I think that this is something that Peter was alluding to a few moments ago. You know, you can have a self-regulatory mechanism established through law or through an agreement by, or a mandate by legislative bodies. So in the United States, the Children's Online Privacy Protection Act, which is one of our chief laws for protecting online information about children, that law actually set up some standards for self-regulatory mechanisms, and it allows for self-regulatory organizations to exist and creates a safe harbor program so that companies that work with a self-regulatory entity will be able to have a safe harbor so that we at the Federal Trade Commission would not be the first line or the first entity that comes after a company that may be involved with a potential violation. Instead, the self-regulatory organization will be monitoring these companies on an ongoing basis. But we also have strong enforcement actions and strong enforcement authority with respect to entities that are a part of a safe harbor mechanism as well. So you can have a legal mandate that's set up by Congress or set up by a legislature. You can have a mandate that's set up by agreement between countries. So the EU-US safe harbor is another self-regulatory mechanism. And the standards by which companies are supposed to, the standards that companies are supposed to live up to if they're going to be part of that safe harbor mechanism are set, were set actually by the Commerce Department with the concurrence of the European Commission. So there are different ways that these standards can be set up. I'd say that the last way the standard can be set up would be by industry itself. And we're seeing some of that through the W3C and through Do Not Track, and maybe we'll be talking about that as time goes forward. I think one of the critical components there, when industry itself is setting up the standards, is to ensure, again, that no one entity that may have a dominant position is driving the discussion so much that other players really won't have the ability to participate in that self-regulatory mechanism. So those are some initial thoughts.
Terrific. Sigrid, please.
Yes, thanks. Well, first of all, let me tell you that, and I will send you an apology and a hello from Dr. Jacqueline Bouchard, because she was really the one that was intended to be here at the table. But we're in the midst of a very profound changing at E5 because the senators decided to renew our body of law on the access of information. E5 have responsibility for two rights, the access of information and the data protection. But in terms of the data protection, because we came very new to regulate the private sector, it's important to underline that in our first consultations, we really worked very closely with the Ministry of Economy. Our private sector was clearly very worried that the strict approach towards enforcement companies would pay a very high price to be the top on the course of adapting themselves to all the regulations that data protection accompanies these regulations. And for us, in our first approach to the universe of the private sector in Mexico, we estimated that we had nearly 3 million medium-sized companies. We were not, and we still are not, very concerned about the big transnational companies, because we depart from the point that those big transnational companies that set work in Canada, in the US, or even in Asian countries will be already abide by international standards at APEC, OECD, or the Council of Europe. So for us, the challenge remains to be to go into the middle and small size that collect a tremendous amount of personal data, and that we could work in a very collegial enforcement character by approaching directly certain sectors that we thought that were critical. So we started our alliance with the society, with civil society, but particularly with the sector of the banking and health industry, as to see how the business sector could tell us much more on how they work, how they regulate it, how much data they protect. They are bound by our law to create a system of self-regulation, but once they communicate and establish the self-regulation mechanism, we can monitor them. And that's the way we've been building the alliance with the private sector in conjunction with the Ministry of the Economy of Mexico.
Excellent, thanks very much. The next two questions, first is for Peter, and the next one is for Josh, because I want to get into some particulars of self-regulation. And this has to do with the RFID industry standards that were approved by the 29 Working Party, and which are in place. And I wondered if you could maybe comment on how you think it's worked out, and how will self-regulation be viewed under the proposed regulation?
Well, the self-regulation on privacy in the field of RFID chips was a process that needed a lot of time. And there were also to discuss many conflictual situations. And at last, we found a common basis that to formulate, to write down a kind of framework for privacy impact assessments for RFID chips. The framework means that there are some common requirements for such privacy impact assessments that should be carried out if industry wants to implement RFID chips. This was the idea. On the paper, it looks very fine. But if you look into the practice, I'm not so optimistic that this is a success story until now. Because there are only very few privacy impact assessments carried out by the industry following this framework. And although there are no privacy impact assessments, RFID chips are implemented. So the question is, what's the value, what's the incentive for the industry to follow such approaches? We as data protection authorities are players in this field, and we have to deal with that, and we have to convince industries, convince means also to enforce, that it makes sense to meet these standards set up by this framework. You ask also what will be the role of self-regulation in the new European data protection regulation, especially in the field of privacy impact assessment. It is new named data protection impact assessment, but I think it means more or less the same.
Yes.
Is that should be a voluntary means, but in these procedures to formulate these privacy impact assessments or data protection impact assessments, there should be a close relationship between data protection authorities and in both industries.
Well, in fact, the DPAs would have the opportunity to look behind the PIAs when they come in and...
That's it. Not only leave it to the industry, but also to ask whether the standards meet the legal requirements, and on the other hand, how far the practices comply with these standards. So I think it is too early to come to a final judgment on the PIA framework for RFID, but the starting point was a little bit difficult, or the starting procedures. Now we are in a very difficult situation of implementation, and perhaps in one or two years we will see whether it will be a success story or not.
Okay. Josh, another particular example has to do with the self-regulatory work and the recently developed APEC cross-border privacy rule system, in which the U.S. and Mexico will be participating. You were part of the development of that, so I'm interested in your views on that arrangement.
Well, self-regulation, going forward, I'm going to be referring to self-regulation to mean voluntary but enforceable. That's my point about the critical aspect.
Would you call that co-regulation? Voluntary to
yeah.
enforceable?
Yeah, I would call it co-regulation. Very briefly, for those of you that aren't exactly familiar with the structure of the cross-border privacy rule system, I know a lot of you are, but for those of you that are not, it takes the APEC privacy framework, the 9 privacy principles that were developed in 2004, that are based themselves on the 1980 OECD guidelines, and breaks them down into 50 program requirements or controls. That process, the specifics of the actual program requirements, which is basically itself the self-regulation, the code of conduct, took more than about 2 years to develop. Because we did this in a public venue, multi-stakeholder forum in APEC, everything has to be consensus-based. That means you have to get 21 member economies to agree to a particular program requirement. And not only that, but we did it in consultation with both private sector, academia, civil society. We had some ground rules going forward in terms of putting forward actual program requirements. The first was that anybody that wanted to make a suggestion as to a program requirement needed to make a demonstration of how that requirement specifically tied to the APEC privacy principle. Now, the reason that we had to keep such tight controls over this process is because we only had the remit to develop a system that implemented the privacy framework. That was the endorsed document by these economies. So with that in mind, we went forward, and it did take quite a bit of doing to be able to actually move from principle to program requirement. But that was the process that we undertook. We're now complete with that and with the development of the whole system. But again, all of these program requirements, if a company wants to seek certification, that company first needs to go to a third-party certifier, which we refer to as an accountability agent. The standards for who can perform those certifications themselves took quite some time to develop. And they can only do it in jurisdictions where the economy has demonstrated that each of those 50 requirements can be enforced under law. Now, this is what the United States accomplished when we submitted our notice of intent to participate. Our Federal Trade Commission went through each of the program requirements and explained how it is that under U.S. law, when a company holds itself out as being in compliance with the CBPR system, how that's enforceable in the United States. And this is what Mexico recently did as well. Now, these documents, once they're completed, will be made publicly available. So beyond just actually implementing the system, which I think is a value, obviously, in and of itself, we have a way to socialize very different approaches to the protection of personal information in a very clear way around a baseline. And again, I should be very clear about this. This program is not designed to displace any national efforts at the development of privacy protections. Those local developments that exceed what we are developing in APEC will always come. This is meant to be able to sort of form a bridge between different countries that might have very different approaches to the protection of personal information. APEC is a particular challenge because we literally span the globe. And we go from South America to East Asia and everywhere in between. And so to be able to get consensus on specific points, not just from the economies and the regulators in those economies, but from the industries and from civil society, that took a lot of work. But it is done. And I think it is a value. And I would encourage all of you, if you have interest in how this system developed, some of the challenges that we were able to overcome, to please seek out that information. Because one of the things that we have to do now is to be able to make sure that this system is actually taken up, that industry actually finds a value in it, that economies actually find a value in it.
Thanks. Sigrid, do you have big reactions to that self-regulatory regime?
What I would add to what Jorg is saying is that for Mexico it was critical to be part of this, especially because of all the commerce we're doing with APEC in the region. It became fundamental for us working together with the Ministry of Economy and also with the business sector that is already working on that direction. And that also took a lot of consultations within our own country, because it was not only that the Ministry of Economy was interested, but we had to build up a consensus of how to follow up on the documents, the principles, and how to match that in order to prove that even when we would be doing the self-regulation, the monitoring was going to be at place so we could join this effort, and we are just on the road of doing that.
Excellent. So bear with me for a moment, because I want to read from a report by the Information Technology and Innovation Foundation. It's a slightly long excerpt, but I think it's important because I want to get the reaction of each of you to the observations about self-regulatory organizations. Here I'm quoting, and it starts by saying, opponents of self-regulation may incorrectly assume that self-regulation is necessarily weaker than state regulation, either because it has less stringent rules or because it ineffectively enforces its rules. First, self-regulatory organizations can be effective self-policing organizations, particularly when the institutions are designed to eliminate conflicts of interest. Many SROs begin enforcement actions in response to complaints. Businesses provide a high degree of oversight since they regularly monitor the activities of their competitors and have an incentive to report violations. Second, SROs can be more effective than government agencies at rulemaking. When businesses come together to develop rules, those involved are likely to have a higher degree of technical and industry expertise than an outside regulator. So there's a defense of self-regulatory organizations as a part of self-regulation. Why don't we start at the other end of the panel? I know you're ready to comment, Peter, but let's start at the other end of the panel. And just work our way up and get your reactions to those statements.
Thanks. Well, the first thing I would say is that you have to take into account an experience like in Mexico, where we are coming to terms on handling the personal data. So for us, it was critical to build knowledge even within the private sector so they could build up the capacity to self-regulate. From the point of view of our law, what we have is that we come to terms with the sector because we, from the standpoint of view of the IFI, we are experts on data protection, but we are not necessarily experts in finances and banking and health. So we do need to reach out to the sector, have a dialogue, see what are the other stakeholders that are participating in this, and from that, take it to build up a self-regulation framework that will allow the data protection authorities to come and monitor them with a mandate, which is, from our point of view, we are not intending to become an obstacle of commerce, of transfer, of the value that today data protection has for the international economy.
Julie.
Sure. You know, it's an interesting quote, and I know the folks who wrote the piece, and I thought it was an interesting piece. I agree, this sentence may have a lot of negatives in it, so I apologize. But I agree that self-regulatory mechanisms are not weaker. I mean, I think I mean, on some level, of course they are. I mean, you know, with law enforcement, you can assess penalties. I mean, we just assessed, you know, a $22.5 million penalty against Google as a result of its violating a consent decree. I mean, self-regulatory organizations are not going to do that. We assessed penalties against Playdom of $3 million for violating COPPA. We assessed penalties of $1 million against Artist Arena for violating COPPA. I mean, the safe harbor organizations don't do that. So if that's your measure of weaker, yes, I suppose a self-regulatory mechanism is weaker, but that's not how I measure the value of a self-regulatory mechanism. And I don't think that it's actually helpful for us as privacy regulators to measure them along those lines. I think what's helpful is instead to look at the self-regulatory mechanisms as complementary of law enforcement. Look, for those of you who do law enforcement, who are out there, I see a bunch of my comrades in arms out here, you know, we are all struggling with resource issues. We're struggling to keep up with all of the cases that we could possibly bring, struggling to keep up with how we can prove those cases in court. Self-regulatory mechanisms serve an important role by filling the gaps in law enforcement that we just can't fill because of our resource constraints. That's just the reality of how business is done. And the Federal Trade Commission, you know, there are certainly other organizations that do equally as much law enforcement as we do, but I don't think there's anyone who does more law enforcement around privacy than we do at the Federal Trade Commission. And we do see a very valuable complementary role that self-regulatory organizations can play. And, you know, some of what you read, Chris, in that quote about their ability, that is the SROs, the self-regulatory organizations' ability to be more nimble, to be able to respond to more technical issues. Gosh, if any of you have sat in on any of the conversations going on in the W3C, you would know that that's a conversation that industry needs to be having. It's not a conversation, certainly governmental entities should participate, should know what's going on, but at that kind of a technical level with respect to standards, it's very important that industry be able to talk and develop some of these standards to the extent that they're able to.
Do you think we're at the point today, I'm just speaking about the United States, where industry is anticipating a tougher framework and therefore adopting some self-regulatory mechanisms?
Peter and I were chatting about this issue just before, and I know he'll have some things to say about that. I think there is a role for policymakers to strongly encourage industry to step up to the plate. And Lord knows, those of you who listen to my speeches, like over the last year, Chris, I know you've listened to them, and others out there probably have. I, for one, take the bully pulpit that I have, such as it is, however large it is, very seriously. And I spend a lot of time encouraging industry to step up to the plate and develop appropriate responses to consumer problems as industry, maybe through what we might call a self-regulatory mechanism, but even however it gets done, so as to avoid potential legislation down the road. So I do think that it has a role.
So that's a slight cue for a shout out to my co-chair of the Future of Privacy Forum, Jules Malinetsky, who just worked with Trustee and others to develop a seal for smart grid use of smart grid data by third parties. And I think that was certainly promoted by the entry into the field of the Public Utilities Commission to potentially regulate. Jorg. My BlackBerry's not working, so I know that's not me.
It's okay. No, I very much agree with Julie Brill. I think industry has really a very important role to play in this field. They have the responsibility also to protect privacy and human rights, and I think they can only win also on that account, because the business and industry that is seen as privacy friendly or compliant will be also more competitive in the market. And it's clear that the expertise and knowledge is very much in industry. It's not so much often governmental experts lacking this expertise and knowledge about the latest technology. So that's really also why in the Council of Europe we very much promote this multi-stakeholder approach. And in the current revision of the convention, I would also like to my colleague and on the left, we've also taken up some ideas or concepts developed in the APEC framework. There is the idea now to bring into the convention things like privacy impact assessment and privacy by design, precisely because we recognize that these are things that if you want to have an instrument that is acceptable on a more global level and is also effective in its reach, you have to introduce these concepts now. Just to give also two examples where we have worked with the private sector. Many years ago already, we developed together with the International Chamber of Commerce some rules on the preparation of contractual clauses for governing data protection during the transfer of personal data. And this was very much developed with industry and together also with the European Commission. And more recently, a very interesting initiative, we are working on a project, a joint project with the European Union in Ukraine, where when they adopted the data protection legislation, it was very much used, in fact, to hinder the free press, it was used as a pretext to no longer give access to the press, to deny access to the press to certain information, or to sanction them when they reported certain private, allegedly protected by privacy facts about politicians. And so we took the initiative, and we have developed, in fact, recommendations on the protection of privacy in media coverage, together not only with the state authorities, but with the journalist associations and also with all stakeholders in the field. And they are based very much on the internationally agreed standards in this field of the case law, of the Court of Human Rights, of course, in Ukraine being also part of the European Convention. But they are very practical. It's clear that in these areas, it is very important to involve the different stakeholders. And these recommendations, they will be available soon also on our website if you're interested. But I think what we must avoid, I think there I see, of course, an issue. However beneficial self-regulation is, and I think it is really, you really need it, but you must avoid that it becomes a pretext for not doing enough on the side of the state authorities and not at least legislating on the basic features, baseline principles, so they're sometimes called, for data protection, because there you need a legal framework. Otherwise, self-regulation becomes like a car's turning signal. Someone might flip on their right blinker to let you know they want to change lanes, but you aren't required by law to let them over. And in particular, the big car, Porsche Cayenne, you may not pay much attention to the small car, which is on the left side.
Well, I think going to my previous discussion about what I saw were the essential elements of self-regulation, specifically the point of accountability. Within the APEC context, that is accomplished through the use of, as I mentioned, accountability agents or third-party certifiers. And our experience in developing a mechanism that can be used to control these kind of deputies that can help to make sure that companies are compliant with these obligations. The last portion of the quote that spoke specifically to the expertise that might be housed in industry. This was something that I think held especially true as we developed this piece of the system. And that is because the representatives, the delegates to the meetings really had no experience in the practical operation of what a trust mark actually does day in and day out. Now that's not to say that trust marks are the only folks that could perform that kind of a certification function. We also have gotten some expressions of interest from accounting firms, but the same holds there. None of us had any expertise in how an accounting firm is run. So as we set about developing rules to try to guide how they can be ushered into the system and also how they can be ushered out of the system. We really needed them to be in the room, to be able to explain to us what is and is not a viable business model. Because in a lot of instances, these folks are private sector. Not in all instances. But if they are operating in the private sector, they're going to be operating under a particular set of constraints. Now, those constraints might not necessarily be understood by the people around the table, certainly weren't understood by, me, the Department of Commerce. So being able to get that kind of information really did help us to be able to put together a system that would be enticing for these accountability agents. Because again, if this is going to have any success, it's going to have to be taken up, not just by industry, but by the folks that we're looking to perform the certifications. So having them there was critical.
So we're going to go to Felipe and Peter in a moment. Lillian's given me special dispensation as a member of the EPIC Advisory Board to run over a little bit. So we're going to finish these answers. Then we're going to go to the people who are poised, like Pat out there, ready to jump, and a few other folks. So we will run over just a little bit. We'll try to finish as close to 6 as possible. Felipe.
Reitero las palabras con que empecé hoy. No podemos caer en una opción adversativa de una u otra. La legislación es necesaria, pero de todas maneras, digo legislación cosa nacional, pero también a nivel de tratados, a nivel internacional. Pero si esta legislación puede ser muy buena, pero no ser efectiva, no es útil. La autorregulación en ese sentido puede ser un paso de efectividad mayor. Por lo tanto, yo esa pregunta, si es más débil, no estoy de acuerdo. Yo creo que puede ser más fuerte. Por lo mismo, tiene que ser complementaria. O sea, si existe responsabilidad social, si las empresas tienen un compromiso de calidad, sobre todo en un ámbito de una asociación representativa, pueden ser exactamente una fuente de derecho verdadero. Pensaba hace un rato cuando se conversaba acá en materia laboral. Los convenios colectivos de trabajo son fuente de derecho con valor y se respalda por la legislación sin provenir de la legislación. Por otra parte, la autorregulación puede llevar perfectamente a infraestructuras tecnológicas de privacidad auditables y que eso lo respalde la legislación. De manera que estimo que no tenemos que caer en una oposición, sino que pueden ser perfectamente complementarias. Y como creo que también dijo Jorg, y lo había indicado yo, la legislación tiene que marcar los grandes principios, quizás el fundamento, el sustento de eso, pero no detalles que quizás sean mucho mejores dados por esa autorregulación. De manera que yo, la cita esa, puedo decir que la comparto.
Excellent. Now, I was joking with Peter that as in our presidential debates that are going on right now, having the last word has some advantages.
Well, thank you very much. To be frank, I'm much more skeptical as the self-regulatory organizations, the statement you mentioned. Because we have collected some experiences with self-regulatory approaches. There's a common pattern in Germany, at least, but I think it is not only happened in Germany. At first, something goes wrong. So, Google Street View, we have a big debate on how far data could be collected without the consent of the individuals, and which data could be collected for which purposes. Another example was Facebook face recognition procedures they have implemented in their service recently. So there was a discussion. Then second phase is that there's political pressure. There are politicians saying we need strong regulation, forbid this, please. We need new laws or to make our we have to make our laws more effective. So then the answer from the industry comes, well, are there other ways? Let's try it alone, and the answer is self-regulation. But at the end, those self-regulational approaches were not so positive as the industry proposed in the beginning of this procedure. At first, it needs a long time period of discussions to come to any results, and if there are results, these results in many times are below the legal requirements. We have also had such experiences with advertisers on the do not track me requirements of the e-privacy directive, where industry provided a self-regulatory framework, a code of conduct that did not meet the legal requirements in Europe. So this is not a positive result. But in some cases, there was a side result of such discussions, because the public discussion in the situation, if the things goes wrong, is very hot. But after weeks and months, nobody remembers. So the right to be forgotten is practiced in this field, and the proposed self-regulation is one element of the right to be forgotten. Last but not least, the question is, what are the incentives for self-regulation? Well, I think we have to think more about this. Incentives, and perhaps positive incentives, negative incentives. Positive incentives might be that those who are setting up the self-regulatory frameworks have positive results for their business. They can set up trust with their customers. Negative results might be also that if there is no self-regulatory success, regulators have a very strong enforcement power. So we need carrots as well as sticks, but in reality, sometimes we nor have carrots or sticks.
Julie, you had a comment?
So just to follow up on that a little bit, you know, as I said, I do think that self-regulation it gets a good impetus when there are some incentives. I guess, Peter, you would call that a stick as opposed to a carrot. And, you know, clearly, you know, whether it's just the law says that a safe harbor will be created, that I guess would be a carrot. A safe harbor would be created as with COPPA, the Children's Online Privacy Protection Act, or the EU-US Safe Harbor. You know, those are good ways to sort of foster self-regulatory mechanisms. So I agree with my esteemed colleague from Germany. But I want to point out another phenomenon that we've recently had experience with, and it comes out of what you just mentioned, Peter, with respect to Facebook and facial recognition. You know, after the photo tagging became more ubiquitous on Facebook, we at the Federal Trade Commission began thinking hard about facial recognition issues, not just with respect to Facebook, but with respect to all manner of facial recognition. And what we did was, rather than sort of say, pass it off to industry and say, you guys figure this out, what we did is we held a workshop where there was a lot of discussion about both the benefits of facial recognition, how it can be quite useful in terms of security, actually, and in terms of privacy, and also what some of the potential problems might be. And just today, we issued a report based on the discussion at that workshop, where we outline some best practices that we're hoping very seriously industry will take a hard look at in terms of dealing with facial recognition issues. So that's another way. Look, it's not, we didn't pass it off to industry and say, you guys figure this out, although there is no law that's currently on the books right now. What we did develop were simply best practices, but we brought industry together to try to talk about this with us in the room and try to figure this out. We had great presentations, and now we've issued a report. We're hoping that that report will actually inform not just folks in the United States, but also around the world with some of the benefits, but also some of the tremendous potential problems with respect to facial recognition. So that's another way that some of these issues can be addressed on a going forward basis.
Many thanks for that. So we're running into overtime. I want to go to questions and answers, but I'm going to exercise my moderator's prerogative and ask that the questions be short and that the answers be short. So Nigel Waters, I think, has the first question.
Thanks, Chris. Civil society, I think, would generally be pretty sceptical about the role of self-regulation, even within a co-regulatory framework. and we'd probably be at certainly at Peter's end of the spectrum of scepticism. I guess we're hearing from all of you, reassuring statements about the criteria that you would accept for the role of third-party intermediaries or accountability agents. But I'd suggest to you that you're underestimating the problems and the challenges that are faced, and there are three particular ones I'd like to just highlight. One is the inherent conflict in a profit-based business model for accountability agents, particularly where you've got an accountability agent which is playing dual roles, both of certifying businesses, taking their money to give them a tick for being compliant, but then also potentially playing a role in terms of the first level of complaint handling. I think that's a really serious conflict of interest.
So Nigel, you're going to put a question mark at the end of all this?
Yeah. Second major challenge area is dispute resolution, that where accountability agents do play a dispute resolution role, you've got the problem of complaint fatigue, that where individuals, having gone to the organisation in the first place to complain, they then get sent off to a third-party intermediary, quite likely to give up before they get to the regulator with the real powers. And that's the practical experience of multi-level complaint systems. And the third one is the lack of accountability and transparency, that unless we can guarantee that the third-party accountability agents are at least as transparent and accountable as the DPAs in terms of complaint statistics, reporting, annual reports and such like, then we've got a major problem. So I guess the question is, on all three of those counts, don't you think possibly you've underestimated the problems?
Okay, or maybe we'll reframe it by saying, can those three criticisms be overcome? Any of the panelists want to address that? Josh?
I think, in particular, we're talking about some of the processes, Nigel, that you're well familiar with, that we've established within APAC to account for some of this. One of the things that's required of an accountability agent is to be able to demonstrate how they meet a set of recognition criteria. One of them is conflicts of interest. Now, what ends up happening is that they will provide to APAC member economies an explanation of how it is that they deal with these internal structures and whether or not they in fact have policies in place to avoid conflicts of interest. Now, at that point, it becomes the judgment of all the member economies. And I would submit that if 21 member economies in their independent assessment find the answer satisfactory, it's provided by that accountability agent, then there's a pretty high likelihood that it is in fact a legitimate set of policies and practices that they have in place. That also goes to the point around transparency, in that these countries are going to have the opportunity to look as closely as they want to at these proposed accountability agents to make sure that they are satisfied with the answers that have been provided, and to make sure that they in fact comply with the recognized criteria. Now again, you can't pull the plug on these folks for any reason under the sun. You have to be able to go back to the recognition criteria. You have to make a for-cause claim. And that became very important when we're trying to incentivize accountability agents to join up to the system to begin with, because what good is it of a business model if they can get yanked at any time? So the balance struck there is, look, let's all negotiate these recognized criteria. Let's negotiate the terms under which you can get pulled from this system. Now, if that happens in an economy that wants to put forward its own accountability agent, they have all the control over the sun that they want, that they would like to have over that accountability agent. So in the instance of Mexico, they're developing, and I know you can speak to this, independent regulation that would be used to put forward or use accountability agents or certifiers that can actually participate in the system. So I think it's important to note that we have attempted to address these challenges. We may well have underestimated how difficult a task is in front of us, but we've at least begun to try to address them. And then we'll leave it to the public, and particularly to the member economies, to render their judgment as to whether or not they think the answers and the policy prescriptions given are satisfactory.